name is Paul Cyan, Realtor with HER Realtors, licensed in the state of Ohio and Kentucky. Today with me is Chris Finney of Finney Law Firm. Also, are you the owner of Ivy Title, a part owner?
Ivy Pointe Title, yes, I'm 100% owner of that as well.
Okay, well, thanks for being on my podcast today. Why don't we get started into the question and answer session? I was going to ask, first question, can you explain to us what a title company does?
Well, it's funny that you asked that because I've been doing this for 20-some years in addition to my law practice. And the other day, my wife said to me, what does a title company do? Because I've talked about my title company, and she knows a little bit about it, but she really didn't know. So, in conjunction with every purchase of real estate, someone should check that the title is good down at the courthouse. And that means a lot of things. It means that the owner hasn't filed bankruptcy. It means that he doesn't have certain kinds of liens against him. It means that he's the fee simple owner of the property, meaning he's got the deed to the property. It means that we know what the mortgages are that are outstanding. It's a whole series of things, and in fact, a good title examiner will check in 5 or 6 different places to confirm good title. But a title company, in essence, checks the title to real property and then insures that title to the lender, the purchaser. You can even insure to a tenant, a lessee, that title is good, or if it's not perfectly clean, which very few of them are, it explains to the owner in the title policy what the encumbrances against title are.
Okay, and you mentioned insurers. Is that the title company themselves writing the insurance policy, or is that they write a statement and then somebody else is providing the insurance coverage?
Yeah, most local title companies are agents for a national underwriter, and then the underwriter actually issues the policy. So it's just like buying homeowners insurance from your Allstate agent, and then the national Allstate or whoever it is writes the policy.
Okay. Okay, then why don't you explain what's the process of title search? What's done and how is that done? Where is it done?
Well, in Ohio, it's mostly done in the office of the Hamilton County Recorder, and there you'll find recorded mortgages against the property, deeds of record, any easements, liens, and then for residential subdivisions, for example, you'll have a series of covenants against the property and a plat of subdivision that set forth the promises that the owner has made to the other owners in the subdivision. And they have to check bankruptcy court, they have to check for unpaid taxes in the auditor's office, and there's a few other places that liens can kind of be hidden that they should check, various indexes to assure that every issue relating to the real property, title to the real property, is made clear.
So it's not an easy thing, not a one-stop shop. I mean, it seems like they have to go to a couple different steps. And
Paul, it's probably like anything else. There are people who take shortcuts and do it the simple way, and then there's the right way to do it. And I would hope that all title examiners would do it the right way, but not all of them do. But to do it correctly, you have to go to several various government offices to assure that you've got all the potential problems that can arise with title.
Okay. And you had mentioned covenants along with that, covenants and deed restrictions. Can you explain that a little further?
Yeah. So what happens, let's say a residential development, first of all, many people don't know, but the person who makes the subdivision, who cuts up the land, they have one big piece of land and they cut it into subdivided parcels, is frequently different than the builder. So the subdivision is, the person who makes the subdivision takes one big piece of land, he puts in roads, sewers, utilities like gas, electric, telephone, and then he breaks up that property into subdivisions, and he makes money doing that. He then sells the property to one builder or to many builders who then build the houses and sell the end product to the buyers. Typically, when that one owner owns the land, he places against the property what they call a declaration of covenants, and he places against the property a plat of subdivision. The plat of subdivision basically takes that property and cuts it up into individual lots. But it also does many other things. And then the text on the face of that subdivision plat, there will be covenants and promises. And then the declaration of covenants might be as short as 7 or 8 pages, and it might be as long as 100 pages. And it contains all kinds of you can't put RVs in the front yard or boats. You can't leave kids' toys out. You can only park so many cars in your driveway, and so on. Some say you can't display signs in your own yard. And then beyond that, they many times have a homeowners association that collects dues, enforces rules, and then maintains the common areas, which might be an entrance monument, it might be a party hall and tennis courts, it might just be a detention basin. And then finally, in those covenants, they many times have design restrictions. So your house has to be a minimum of 3,000 square feet. It has to have brick exterior. It has to be set back 20 feet from the road, and those sorts of things. Now, the important part of that is, think about this. The subdivision plat and the subdivision covenant are just signed by one person, the developer, and then he places that of record.
Okay.
But the effect of that document, whether it's 8 pages or 100 pages, along with the plat of subdivision, is that it becomes a contract by and among the subdivision lot owners when they buy a lot. So if you think about it, very few of us in our lifetime have signed a 100-page contract.
True.
Normal homeowners don't just go around signing big, fat contracts. But when you buy a house that's in a subdivision that has a 100-page declaration, you have effectively signed a 100-page contract because you're agreeing as an owner in that subdivision to all of those promises, whether you know about them or not. You're bound by those promises because they're a record in the county recorder's office. And most homeowners don't really fundamentally understand that those documents bind them just as if they had signed them themselves.
Okay, and that's an ongoing thing, usually, in essence, forever.
Most subdivision covenants extend in perpetuity.
Okay, and then what happens if somebody happens to break a covenant, whether intentionally or unintentionally?
Now, like everything in the law, that can be a complex question, but as a simple answer, that covenant theoretically can be enforced by every single homeowner in the subdivision individually,
okay,
and by the homeowners association. And I would say the vast majority of subdivision documents that I have seen in Ohio have a fee shifting provision, which means that if the association is forced to sue the homeowner to enforce a covenant, it might just be to collect the monthly dues, or it might be because you build a shed in your backyard that you're not allowed to build. They also can collect their attorney's fees for the enforcement of those covenants.
Okay, so it sounds like it's something that people need to pay attention to, and they do violate it, they might have some other issues to deal with.
Well, they always say read the fine print. Well, when you buy a house in a subdivision, or if you buy a condominium, and you don't read the declaration, and you don't read the plat of subdivision to understand what the covenants are, you're buying into a contract that without knowing the terms.
Yeah, or if not read it, at least talk to your attorney and get them to read it for you and give you an opinion if you're going to do something.
Correct, and we're hired from time to time just to read these long documents and give people a 1 or 2 page summary of the highlights of the things that might be important to you. Let me tell you a funny story of one that I had years ago. A client of mine was buying a condominium in a high-rise in Cincinnati, and he was a corporate executive that traveled a lot and really had a hard life. I mean, he pushed really hard. But he said, when I come home on the weekends, I just want to grill out a steak on the back patio and enjoy myself. Well, I read the covenants, and one of the things it said, because it was a high-rise, it said you cannot have a charcoal grill out on your back patio because, the smoke will waft up onto the other units, and he wasn't allowed to do the one thing that he wanted to do with that condo. So it's important that you read those covenants. You never know what's going to be in them.
Yeah, that's a good point. Talk about, we already talked a little bit about title insurance. Why don't you talk about what title insurance can do protection-wise? Somebody comes along and buys a house and, they find out later there's a term they call clouded title. What can you tell us about that, and how does title insurance protect that?
Yeah, first let me just give you a few examples of the kinds of real problems that clients have had with title over the years. One, I had a client that bought a piece of property. He didn't buy it through me, but he came to me with a problem later, and it turned out he had a $20,000 lien that was owing to the IRS against the property that a good title examination would have caught if they had searched. I have had another one in a subdivision in which every single house was built onto the lot next to it. They just had screwed up the survey, and every house was built 10 feet off of where it should have been, so it actually encroached on the property lines. Sometimes the issues are much more minor, like a 6-inch setback violation. But what I normally tell clients is that title problems are rare, but when they occur, they typically are fairly expensive to fix.
Okay.
And so that's kind of the starting point. So the question is, what happens? I bought a house or I bought a commercial property, and I've now learned that I have a title impairment. As a starting point, most buyers get from their seller a general warranty deed. A general warranty deed is a promise from the seller to the buyer that you've got good title to the property. And that's a great starting point. The problem is many sellers, for lack of a better term, don't have a pot to pee in. They don't have any money. And so when you go after them to pay for this or that title problem, there's nothing there. They might have died. They might have moved out of town and you can't find them. They might just be out of state and it's not economically efficient to sue them and collect against them. Mm-hmm. So it is a great deal of comfort. I don't want to minimize it that you have a general warranty deed from a seller, but it's by no means an assurance that you've got title protection. Now, that's where the title insurance companies come in. They say, look, we're going to insure the property subject to certain exceptions, and they're not going to insure over known covenants. So if there's a set of covenants against the property or an easement that's been of record for many years, they're not going to insure over that. But for everything else that becomes a problem, they say, we will provide you with protection. Now, here's the important part. When you go to a closing, many people, well, first of all, when you go to a closing, the lender typically requires you to buy a lender's policy of title insurance that benefits the lender only. And many buyers go through this thought process in their mind. They say, well, I'm paying for a title insurance policy for the lender. I've already paid somebody to search the title. The title, and they say things like, oh, the house has been here for 50 years. Or even better, it's funnier, they say, well, this is a brand new subdivision, and therefore the title must be clear. So they reason in their mind that they don't really need to buy an owner's policy of title insurance for those reasons.
Yeah.
And all of those are false. So first of all, in the first one, when you pay for a lender's policy, the only thing you get is coverage for the lender. And the fact that the subdivision is new or old, or the house has been there for 5 years or 50, is largely irrelevant to the title analysis. You can still have very expensive title problems in all of those circumstances. And also the fact that somebody has in fact searched the title and you've paid for it, which should give you some comfort, doesn't. And there's Ohio and Kentucky law on this very point. And this is the message of this. If you don't buy an owner's policy of title insurance, which is a one-time premium, and they credit against that whatever you pay for the lender's policy, so it's sort of a bargain.
Okay.
But if you don't buy an owner's policy of title insurance, you do not have that secondary protection. You still have the protection from the general warranty deed, but you are not insured if a title problem arises. And people have tried every legal theory to get around that problem, and it doesn't work. A title company, because they're doing the closing and because you paid all these fees, doesn't provide you any assurance of title.
All right, that's good information. Let's. You had mentioned a little bit about general warranty deed. I know there's other types of deeds, quit claims, and a few others. Why don't we talk about the deed types and what are the pros and cons of each? I know with a quit claim, it's kind of like it's worth the paper that it's written on.
That's exactly right. So there's 4 basic types of deeds in Ohio. The most common in residential and really in commercial transactions is a general warranty deed. And the way the language in a general warranty deed typically works is it says that the seller warrants the title to the buyer except for easements, covenants, and restrictions that are of record. So first of all, as a starting point, if there's something that's a record, once again, you're bound by that, and nobody's giving you any assurance against things that are of record. So you need to check the title. But other than that, the general warranty covenant is a pretty broad assurance from the seller to the buyer that you have good, clear, and marketable title. And interestingly, let's say since 1920, the house or the commercial property in question has been conveyed by general warranty deed from buyer to seller for years. You actually have the right to go all the way down through the chain of title and sue every one of the predecessor owners on that general warranty covenant. Or saying it differently, a seller, when they give a general warranty covenant, it's a perpetual promise to people all the way down the chain of title that they're going to have good title.
Okay.
The second kind of deed is called a limited warranty deed, or sometimes called a special warranty deed. And a special warranty deed says simply that the seller promises that he has not screwed up the title. He has not impaired the title. But he makes no promise as to the quality of title before he bought the property. Just he didn't do anything to harm the title. So it's a much more limited form of deed. And you'll see that many times specified in a commercial contract. Now let me just say, on a limited warranty deed and on a quitclaim deed and on a fiduciary deed, which is the fourth kind of deed, it really enhances the need for title insurance, because if you're not getting any broad and general assurance of title from the seller and you're not buying title insurance, you're buying the biggest investment of your life in many cases with no promise that you're getting good title. And that's, to me, just foolhardy.
Yeah, I mean, you could end up losing everything then and don't have anybody out to look to.
And that's happened. So in Cincinnati, people who've been around 15 years or more remember Bill Erpenbeck and the Erpenbeck home scandal. He's now in prison. He stole the payoff monies for mortgages when people were buying new homes from him. What did that mean if they didn't buy title insurance? It meant when they went after him under the general warranty covenants, he was insolvent. There was nobody to go after.
Okay.
And it meant that if they didn't buy an owner's policy and there was a $200,000 mortgage that preceded their interest in the property, they had to pay that $200,000.
Okay.
So it's dangerous. So if you're getting a lesser quality deed, and even if you're getting a good quality deed, it's smart to get title insurance. The third kind of deed is what's called a fiduciary deed. And when you have an executor of an estate, a trustee of a trust, or some other fiduciary, they give a fiduciary deed. And the fiduciary covenants in Ohio, and again, it depends on the forms in other states, basically say that the fiduciary promises he has authority to sign the deed, but otherwise he does not assure the title to the quality of title to the property. So again, you're getting no assurance that there aren't liens, covenants, easements, and restrictions against the property of record or otherwise. And it calls for prudence on the part of the buyer, perhaps, to get title insurance. And then the fourth kind and final kind of deed is what's called a quitclaim deed. And as you pointed out, this is the weakest deed or the most dangerous deed. The seller says, I don't know or represent to you if I own anything at all. I may own the whole title, I may own nothing. But whatever I have, I convey and quitclaim to you, and good luck. And I'm not even sure it comes with a promise of good luck.
Yeah, sometimes we see that in divorce cases too. I mean, that they're advised the spouse.
If you're going to take a quitclaim deed, that should be a warning sign that the seller thinks there's a title problem, and you really ought the title checked and buy an owner's policy of title insurance.
Okay, that's great advice, actually. Let's talk about how does the title company prepare for closing? I mean, we're getting close to the closing date, and so what is the title company doing as they come to that date?
Well, again, the most important function of the title company is to assure to the buyer, assure to the lender, that title to the property is free, clear, and unencumbered. If the title company is asked to prepare the deed for the seller, to make sure it's prepared correctly and the proper sellers are named and all owners sign and spouses, so you get release of dower. That all mortgage payoffs are obtained so that the mortgage interests are released. That the title policy is written correctly so everybody knows about the covenants if they're buying a policy. And then anybody who's been to a closing recently, commercial or residential, knows that there's just a plethora of paper.
Yes, there is.
Lots and lots of statutory and regulatory forms that have to be filled out. Depending on when you're listening to this podcast, as of October the 1st, 2015, a whole new set of documents is going to be required compared to what's required today. But the title company prepares all of those. Then there's two ways to do closings. In Ohio, and particularly Southwest Ohio, the custom is a roundtable closing, which means you get the buyer and the seller in a room, and they sign all of these documents. You exchange the deed for the checks, and everybody shakes hands, exchanges keys, and phone numbers for the utility companies, and you have what's called a closing. In other jurisdictions, they have what's called a escrowed closing, where the documents, like the deed and the other documents, are signed and submitted to the escrow agent. The money is submitted to the escrow agent. The escrow agent then records the deed, and once he's sure that title is clear and everything's fine, he disperses all the documents and money to the appropriate parties, and nobody actually has to show up for the closing. But the title company prepares all those documents, handles the recording of the instruments, issues the title insurance policies, and then sends copies of the documents to everyone.
Okay. And what should they, say the buyer and the seller, they're getting ready to come to closing, what do they need to do preparation-wise?
Under a typical purchase contract, the seller really has two obligations. Under a typical purchase contract, the seller typically has two obligations. One is to transmit his mortgage payoff statements to the title company so we know how to get those mortgages paid off, and to prepare and bring to the closing and sign a deed.
Okay.
Those are the only two things the seller is really obligated to do at a closing. Now, we ask him to do other things, sign a title affidavit, which promises there's no mechanics liens and property disputes with neighbors, and so on. But those are the two basic seller responsibilities. The buyer, on the other hand, usually has to jump through a lot of hoops to arrange for the financing. He has to come up with his down payment. He has to do all the things necessary to get the bank loan in place. And essentially, the buyer's obligation at the closing is to show up with a check. If he's got the cash in the bank, it's basically an exchange of a deed for a check. Now, there's other documents, but that's the essential transaction. If he's borrowing the money, the bank has all kinds of requirements. That he get a survey, that he pay for title insurance, that he, some commercial deals that he buy an environmental report, sometimes that he get a zoning certification and a traffic study, all kinds of stuff to make the lender happy, which is usually the hardest part of any transaction.
Okay, that's good information. Let's talk about just the differences in title work for commercial property versus residential property. I mean, is there major differences? Is it a similar process? How about the closing as well? Is that same, different?
In reality, it's exactly the same. I mean, the places we check title are the same. The encumbrances are essentially the same. What happens in a commercial transaction is sometimes there's 2 or 3 or 4 zeros at the end of the transaction that didn't exist in the residential. But candidly, the same level of care and attention should be paid in both sets of transactions, regardless of the size. On a more practical level, first of all, on a fundamental level, again, we're exchanging a deed for money. That's the essential transaction that's going on, and that's not complicated. Where it gets complicated are the requirements of the lender. And the lenders usually multiply their requirements. They want to see leases from tenants. They want to verify profit and loss statements. They need environmental reports, traffic studies. They want to confirm utilities. They want to see rent rolls, and on and on and on. They have all kinds of requirements for commercial transactions that may not exist for a residential transaction.
Okay. And one question, too. I mean, you're an attorney, and we're talking about closings. In all the closings I've been to, I've never seen a buyer or seller bring an attorney with them. I mean, how common is that? How helpful is that, or how not helpful is that?
First of all, if you go to Chicago, Cleveland, New York, Los Angeles, everybody has an attorney with them at closing. Nobody would even think about going to a closing without an attorney. In Southwest Ohio, on the other hand, it is more the custom that people come without an attorney, and they save that money. There used to be a guy on the radio, I'm trying to, Bruce something or another, I can't remember his name, but he always said, you have to have an attorney at the closing. I'm not sure exactly how to answer that question since my self-interest is at stake. But it's just kind of like, here's what I tell people, both with respect to having an attorney at the closing and with respect to title insurance. I say, do you own a home now? Yes, I do. Do you have casualty insurance on your house in case it burns down? Yes, I do. Did your house burn down last year? No, it didn't. Well, then you wasted that money, didn't you? The problem with not buying title insurance and not having an attorney represent you at the closing is you don't know until after the closing, in some cases well after the closing, that you really needed one. I'm not pushing it. I certainly respect the vast majority of people who don't do it, but things can arise that could create problems if you're not careful.
Okay, that's also good to know. That's my last question. Did you have any final thoughts or any final comments you wanted to share?
No, I just love what you're doing, getting the message out, Paul, to everybody on these real estate topics and legal topics. It's very helpful and very progressive of you to do that. So I appreciate the opportunity to speak.
Well, thank you as well for coming on my podcast. It's been a great session, very informative. Thank you.
Thanks, Paul.